Hi guys, this is Asal. I'm studying for the bar and I wanted to review my notes with you. So today I'm studying evidence and I'm studying judicial notice. So what is judicial notice exactly? That idea confused me a lot at first, but right now I understand how simple it is. All there is to it is that it promotes efficiency so that there's no waste of time. And what do I mean by that? I mean that when you're trying to win a case, a lot of facts they get thrown at you. Like your client will come to you, they're so concerned, and they'll just say a lot. So what happens is that the court will take certain facts to be as true so that there isn't waste of time. So what do I mean by that? There's some facts that you cannot argue it. And if you wanted to argue it, it would be such a waste of time. For example, let's say that sunset is at a certain hour of the day. Well, that's a fact. You can't argue that. Or let's just say that Donald Trump is the president right now. That's a fact. You cannot argue that. Of course he's the president. So that's what I'm talking about. The next thing I want to do is I would like to introduce this book to you, Crunch Time. I use it for every subject. It really helps me because it really breaks it down and it summarizes everything for me just the way I want it. So what I did over here is I pulled up this exam tip page and I would like to read a couple of things that this page says. It's actually very short, so just bear with me, okay? Over here it says Judicial Notice. Questions on judicial notice are more common than you might expect. This is what this book is saying. And the requirements is a fact may be judicially noticed so that proof of it isn't required if either is generally known in the community, such as Donald Trump is the president, or it's capable of immediate and accurate verification, such as sunset is at a certain time of the day. And finally, there are the procedural issues in here. So pay attention to the procedural issues surrounding judicial notice. For example, the difference between in civil cases, the jury should be instructed that they must accept as conclusive any fact of which the judge has taken judicial notice. And also criminal, which says, but in criminal cases, the judge must instruct the jury that it may but is not required to accept as conclusive any fact judicially noticed. So it says, requirement. Also keep in mind that the judge must take judicial notice of any fact that meets the requirement if requested by a party and supplied with the required information. So right here, this rule over here, it says it's the rule 201C. So you can look it up, rule 201C. I would like to get into this rule just a little bit more before I finish up the video. So this rule 201A, it talks about A and B. 201A and B talks about adjudicative facts, not disputable. So there's two. There's generally known and accurately determined. And then there's a rule 201CD, and that's judicial notice at any stage. So there's two types. There's voluntary and there's a mandatory if requested. And also there's the 201E, which is opportunity to be heard on a timely request, including without notification. And finally, there's a 201F. I just talked about it. The civil and then the criminal. What do I mean? Jury must accept in civil trial. So jury must accept in civil trial. Jury may accept in criminal trial. And finally, no judicial notice in criminal appeals. Judicial notice, that's such a hard word for me to say. That's pretty much all there is to it. It's just a very wordy word. That's it. But it's very simple. It promotes efficiency. Keep that in mind. I really hope you enjoy studying. Good luck.